Hello everyone, this is Advocate Shubham Chopra.
This is Advocate Prashant Kanha and we welcome you to our channel.
In this video, we are going to discuss about various aspects of blacklisting of contractors by certain government agencies. Blacklisting of companies in India by certain state agencies and the central agencies has detrimental effect on the corporate sector. It also has a long-term impact on the business and its reputation. So sir, what is blacklisting?
So blacklisting can be said to be a means by the employer to discipline its contractors. Whenever when the contractor has not performed the tender or the contract in the manner that it was to be, or if there are repeated defaults from a particular contractor, or if there are any means of fraud or misrepresentation, there are various circumstances when it feels that that only by repudiating the existing contract the problem that the contractor is causing would not be met. Then under those circumstances the employer takes the extreme step of blacklisting the contractor, which means that it is actually declining to do business with such contractor in the future. And if the contractor, even if applies for any tender or bids for any tender, its tender or the bid will not be evaluated even for the issued tender.
So as we have started explaining the video with the detrimental effects of blacklisting, so what are some other effects of blacklisting on the contractors?
So let us say that a contractor is involved in a specific kind of business. Let us say it is providing computer peripherals, or it is providing computer services, or even developing an airport, or that very nuance or a niche area it is involved into. So in that niche area everyone may be knowing that contractor, it's the stakeholders are of limited number and everyone knows each other. So let us say that if the contractor has been banned by one employer, so under those circumstances the news of that person getting blacklisted will spread like a wildfire amongst its competitors as well. And if that company has been blacklisted, then everywhere else wherever this company will apply, that bad news or that bad reputation will not gonna leave its back. So when these companies are performing a public contract work or a public work, this will always be a this will always cause a detrimental effect in getting the next contract also. So even the courts have said that blacklisting or banning order may be like causing a civil death. Okay. That company may not be able to work in future or may not be able to get work in future. So it's a penalty, actually it's a penal provision which is used. So it has to be used in a rarest of the rare case, the courts have said. And the due process of law should also be followed, and it cannot be discriminatory or arbitrary.
Okay. So what are the grounds on which a company can be blacklisted?
So as I said that a company can be blacklisted where the problem, where where the employer is not satisfied just by repudiating the contract, that okay, repudiation has been done, but the losses or the kind of activity or the action on the part of the contractor is so detrimental to the business of the employer that only repudiation or cancelling the contract will not help. The contractor has repeatedly done something which is which cannot be you can say that compensated by just by cancelling the contract. Few examples would be that blacklisting is done where false or forged papers are filed at the time of taking the tender, or even when when the person is performing the when the company is performing the contract, it is issuing repeated forged bills. Like let us say that for that the billing was done previously also and next time also it has been done. Let us say that deliberately the material used was of substandard or they were not genuine, or the kind of service or the work which was promised by them, they were actually not having experience of that. So moreover, these actions are taken where misrepresentation is there, where the quality is not met. Specific grounds can be seen in the case laws, but it would be something where malice is involved and that malice is known to the party. It is done knowingly actually.
Okay. And are there any restrictions on the government agency as well while taking such actions?
Well, the Supreme Court and various high courts have said that this is a discretionary power and this will depend on the satisfaction of the employer. But then there are two requirements actually which are to be fulfilled by the employer. Number one, that would be that the principle of natural justice are followed, that whatever action you are proposing and that action is proposed on what grounds, what material do you have, those all things should be informed to the party by means of notice, and then proper opportunity of giving reply on merit and proper opportunity to the other side to present its case, uh, to present its case of defense should be provided. And if all these opportunities are given, then you have to decide upon the penalty or the order with respect to blacklisting or banning which you are going to pass. It should be in proportionate with the loss or the misdoing carried on by that contractor. So overall, the employer has to have this idea that what would be the quantum of the punishment, and it should be in proportionate with the wrongdoing of the contractor. Means it cannot be like, say that ki there was let us say that there was a delay of 10 days, you cannot ban for that. But if there are, suppose repeatedly there have been false documents, false bills, then definitely you can ban them for a certain period of time. That would also not, one cannot also blacklist a company for all times to come. There has to be a time period, and that time period has to be in proportionate with the wrongdoing of the firm.
Okay. Sir, as far as my understanding goes, tender allotment is more like a contract, like it's a contractual relationship. And in any private contractual relationship, the role of courts, where we have to decide that whether we want to do this contract or not, is very limited. So, what is the case with contracts or tender? Has judiciary a role to play?
So judiciary actually has limited itself only to a limited ground where it can be shown that the process of banning or the process of or the blacklisting order is actually has been done due to some biasness. You have to prove malafide, or you have to prove that the banning order or the blacklisting order is not proportionate to the act of the party.
Okay.
So courts only see that malafide, biasness, and test of proportionality.
Okay.
Otherwise, the courts have definitely repeatedly held that it is the prerogative of the employer to take action, and but the court will definitely come to rescue if there is an arbitrary order, because Article 14 is always there for the protection of the any action of the state against any citizen or person.
So here comes my last question, sir. As you have discussed that it has both positives and negatives, positives for the public and negatives for the contractor. So do you think there should be some statutory provisions and there should be some law related to this banning order?
Shubham, the thing is that state has been given power under Article 398 to contract, and when it's like a contract between two individuals. If a person is feeling that okay, the other party is not diligent enough and I should not do business with the other side because it causes unnecessary losses to me. Let us say that there is a contractor who has not made good construction, who has not performed the contract the way it should have been. So ultimately, if the public department is taking services from such a party which is causing undue loss to the government, that means it is causing undue loss to the public. And it's not once, it may be a repeated effort, or there may be fraud or forgery. Under those circumstances, it is the duty and the responsibility of the state or the state department which is actually has entered into the agreement to safeguard itself from any such future action. Otherwise, if the government departments will not take such extreme step of blacklisting people, blacklisting firms, then the quality of the work, not only the quality of work will deteriorate, but there would be no apprehension of losing the contracts prevalent among these contractors. So we can say that, you know, it is a power, or it is the right which vests in the party or in the employer who actually is issuing the tender, to maintain the process sanctity of the contract and to maintain the quality of its works. And the courts have also had, like in Khulja Industries, it has been very specifically said by the honorable court that it is the prerogative of the employer only to decide upon what action it proposes to take against, though it will be open to judicial review on the ground of proportionality and arbitrariness, and on those grounds you can always approach the honorable high courts.
Thank you, sir. It was a very enlightening session, and thank you all for joining with us today.